take a deep breath, and our experts will work through it and get us back going fine. We don't anticipate any, though. Call the case, please, Ms. Dempster. Dipsy.
Malcolm D. Myers as executor of the estate of Charles Price Boone versus Dawna Divine Boone.
We're here from the appellant.
Good morning, Your Honors. My name is Donald Caparella of the Nashville Bar. I represent, along with Patrick Riley, I represent Dawna Divine Boone, and I'd like 3 minutes for rebuttal.
I'm sorry, how much?
3 minutes.
3 minutes, okay.
Yes. Thank you, Your Honors. This case arises from a divorce case, but the issue before Your Honors is strictly a question of law. What is the interpretation of the two contracts that are at issue on this appeal? The only issue is whether the billboard marketing agreements that were entered into 6 months into the marriage are marital property, and whether Dawna Boone is entitled to her share of those contracts. The contracts were entered into in April of 2015, about 6 months into the marriage. They were signed by both husband and wife. The other party was Outfront Media, who was supposed to pay and did pay the proceeds from the sale of advertising related to the billboards that the marketing agreement was designed for. Essentially, Outfront contracted to sell all the advertising. They got 40%, and the husband and wife got 60%. And the parties performed under the contract, undisputed in the record that for nine consecutive quarters, the payments were made. About $359,000 in checks were made to Dawna Boone and Charles Boone, and they both deposited the checks into a particular account. The trial court found that all the income from these marketing agreements was marital property. The court also found that the account that the parties put the income into was transmuted into marital property. David Hogue, who was the Outfront Media person who signed the other side of the contract, testified that it was husband's intent to have wife be a party to this contract so she would receive it after he died. He was much older than her. And he also testified that it was the husband, not the wife, at the time when they were signing the contracts, that demanded that she be made a party to the contract. So,
Counsel, I'm sorry.
Yes.
Just what interest, what did Charles and, is it Dawna, is that how your client pronounces his name? Boone, what did they own, the two of them own to give away or sign? I mean, what was their ownership interest that they contracted in that contract? I guess I'm not saying it very well, but they didn't own the two billboards, did they?
The husband owned the two billboards. And
I'm sorry, did the husband own the billboards, or did his company own the billboards?
The husband individually owned the billboards, although there's a little bit of dispute about one of them. I think the St. Charles was also listed as an owner, but the record, I think, clearly shows, and I think it's disputed, that the husband owned the billboards. But individually
and not the corporation.
I think the record shows that he owned it individually. But that doesn't matter for the analysis, because the husband allowed the wife to be a party to a separate property interest. And the property interest is the contractual right for the advertising proceeds from these. No one is arguing that this contract is not valid. It clearly gives the parties to the contract the right to get the advertising proceeds from this interest. So the contract is a separate intangible property right, separate from the actual real property interest in the billboards. And as a matter of fact, the trial court has found, and it's not disputed, that the income from this agreement was marital property.
Well, what was the basis for that trial court's finding? Was it the fact that it was placed into the account that was transmuted?
No. The trial court found that the past income, separate from the actual account that it was put in, was marital income. And since the wife had got the benefit of that, she didn't make an award as to what that was. Then
where did that income, that past income, go?
It went into a bank account, which the trial court also found was marital property. The issue in this case is not about the income. The issue is, are the billboard marketing agreements and the income going forward marital property? And you can, Your Honor, whether somebody owns the underlying property interest doesn't prevent parties to have a contractual right to something. You can own the right to lease payments from a piece of real property that you don't own, as long as you're a party to the lease. You can give people can contract however they want to contract. And husband made it very clear, according to David Hogue and according to the language of the contract itself, that this is a property right of husband and wife. Well, actually not husband and wife, just Charles and Dawna Boone. And she has a right going forward. And there's no question that this right was created for the very first time, the right to get the income from these contracts, when the marriage was created. And under the statute of defining what marital property is, this is an intangible property right that the wife has a right to. And the trial court has no right to take that away from her, since it's a contractual right that is enforceable. Have I answered your question, Your Honor?
Yeah, that's fine. If the husband's corporation owned the billboards, and I understand you say that you think the proof is otherwise, but if the husband's corporation owned the billboard, could the husband individually assign income to the wife?
Husband is not assigning income to the wife. She's a party to this agreement.
Well, okay. Well, who's the parties to the agreement?
Well, the parties to the agreement are the signatures. Well, first of all, they are defined, the owners in this contract are defined as Charles and Dawna Boone, and they are the only two people that signed. Now, husband signed next to his name, St. Charles Place. He didn't put St. Charles Place, Inc. He just put St. Charles Place, St. Charles Place. The law is, yeah, said present, yeah. The law is that when you sign that way, that's evidence that that person, is signing in a representative capacity. However, that evidence must be set aside when the contract itself never even mentions St. Charles Place one time. It defines the owners of this contractual right to be Charles and Dawna Boone. So the case law is very clear that when Mr. Boone signed this contract and when Mrs. Boone signed the contract, they knew what the contract said and they knew they were the parties. So husband, under that analysis, is a party to this contract, and so is wife. But even if you were to say that the St. Charles Place was the other party to the contract, wife is still a party to the contract. And then it wouldn't even be marital property. It'd just be her contractual right. There's no dispute and can be no dispute that she is a party to this contract and that she got the money from this contract. But we submit the better analysis is that it's marital property because the contractual right is an intangible right that was created after the marriage, and they performed under the contract for 9 consecutive quarters, and she got $359,000, and so does he, and she deposited money into the account. After all, when husband filed for divorce and asked Outfront Media, Your Honor, to stop paying the two of them, but instead pay the corporation, Outfront Media wrote back and said, we can't do that because St. Charles Place is not a party to this. So that's more evidence showing that St. Charles Place was not a party to this marketing agreement. So respectfully, this is an intangible right that that Ms. Boone is entitled to, and Your Honor should reverse the trial court and find that she is a party to this contract and should get 50% of the proceeds. Now, there's an alternative argument, which is the transmutation argument.
Yeah, bro, let me ask you a question, please. First of all, was there a response by the husband as to what the billboard company said his intentions were in creating the contract to provide for the wife?
What was the response to David Hogue's testimony that he intended her to be? I don't believe he directly addressed David Hogue's testimony in that respect. And of course, he would be biased compared to an unbiased witness. I don't think he specifically said David Hogue was wrong when he said that.
Okay, he did not dispute that was his intention to provide for the wife.
I don't know if he disputed whether that was his intention. I do know that he did not dispute in any way David Hoag's testimony. I just don't have a memory to answer your question the way you asked it. I'm sorry.
Okay, well, I may have asked it very inartfully, so if there's any way you want to respond to it, that's fine.
I don't believe the record shows that he disputed David Hoag's testimony that it was husband's intent to put it in her name and his name to provide for him after he died.
And my second question is this. You say that the trial court said that this account was transmuted and that both parties owned an interest in the account. Is that correct?
Yes.
And why did the trial court not do that going forward as far as these rights to payments going forward? Was there any reasoning provided by the court in that analysis?
Not in its order, Your Honor. It's just that when it ruled that all of this property was husband's separate property, the payment stopped to her, and it didn't say why it stopped, why the court stopped it going forward. I guess you can infer that it was because she didn't have an ownership interest anymore. But in any event, the court said that it was marital income, past marital income, as well as dividing that property. But then the trial court cut it off and did not allow it to go forward because the court found that it was owned solely by the husband as a separate property. Now, somewhat confusingly, the court also said it was owned by the corporation. But I think ultimately, if you read the court's order, it suggested that the husband owned it as a separate property because the corporation was his separate property.
Did the trial court specifically find that the wife had no ownership interest in these payments going forward, or that it was the property of the husband or the property of the corporation and that the wife did not possess any ownership interest in it?
Well, what the court said is that the billboard marketing agreements was owned by husband as his separate property. Okay. And didn't say, and therefore wife gets nothing. It just said it was owned and didn't divided the rest of the marital estate. Okay. So that is being owned by the husband. Right. So what we want on appeal, Your Honor, is to declare that this is marital property. Wife is entitled to at least 50% of this and remand it to the trial court. And the trial court didn't value this property. So it needs to be valued and needs to be equitably distributed to the wife. And we also rely on our brief for our request for an award of attorney's fees on appeal.
Let me ask you. I'm sorry, go ahead.
One question. You keep saying that the court determined that these properties was a husband's separate property.
Yes.
That's not what he decided in the order, is it? As I read the order, he decided that these billboards and the agreement itself was corporate property, and that during the marriage, the proceeds were paid to them, but that the property and the agreement itself is really corporate property, is how I read the trial court's order.
Well, there's language to support both rulings, Your Honor, which is that the court said it was the separate property of the husband, but it also said that it was owned by the corporation. I think you could read it both ways, and we pointed out in our brief that it's confusing. But even if the corporation is found to be an owner of this, wife is a party to this contract. So she still is entitled to the proceeds. But I would submit that the more correct view is that this is marital property that was entered into by the husband and wife. St. Charles Place is never mentioned on this contract. It's never referenced in any spec except for it's written in at the end, but you have to read the contract, which never mentions St. Charles Place. It identifies these two people as the owners, and you can't change the terms of the contract by simply signing it the wrong way.
Counsel, if the two individuals didn't own the billboards, if the billboards were owned by a corporation, what right did the two individuals have to bind the corporation to anything?
Well, the husband was the president.
If they had no ownership interest in the billboard, other than the husband owned the corporation.
Well, but I think the record shows that the husband was the individual owner of these billboards.
He was, well, we'll see exactly, but I think kind of like I agree with Judge Armstrong. I thought the court found that the corporation of which the husband was the sole owner, but the corporation owned the billboards.
The court says several times in its ruling that this billboard is the separate, these leasing agreements are the
Counsel,
separate.
I understand that argument, and I understand what you're saying there, but it seems to me the best I can read what the trial court was doing, that, yeah, because the husband is the sole owner of the corporation, that he referred it sometimes to is found as the husband's sole property.
Well, the people can contract how they want to, and the wife and the husband,
they have to own what they're contracting about.
They have the right to contract about it, and there's no question that the husband had the right to allow his wife to get these proceeds, and the trial court has found that this was marital income.
All right, I understand that's your conclusion. I'm going to ask you one more question. Your time has expired, but we were asking you a lot other here too.
Thank you.
What about the fact, how long was it? Was it like 2 1/3 years from the time of marriage to when the divorce was filed? Not the divorce was entered, but when the complaint was filed?
About 2.5 years, yes.
Okay, isn't this and the trial court specifically found this was a short-term marriage?
Yes.
And your client came into it with $30,000?
Approximately, yes.
Approximately, yes. And what you're asking for is that in this short-term marriage, that she be awarded a 50% interest in the 2 billboards.
Right. Based on contract law, yes.
I understand. Okay, thank you, counsel.
Thank you.
We'll hear from the appellee.
Honor, I am Dan Taylor of the Memphis Shelby County Bar Association. I'd like to start off by saying 2 things. First of all, I want to thank Mr. Caparella for his professionalism and the courtesies that he has extended during this process. I did not know him at the beginning of this, but it's been a pleasure to get to know him and to work with him. The second thing I want to touch upon before I address the issues is that I'm proud of the brief that we submitted on behalf of the appellee. I wish I could say I wrote it, but I didn't. Mr. John Bean of my law firm wrote it, and I make a practice of giving him credit for that. And I think he deserves for this court to know that he wrote the brief. Dan Taylor didn't.
Thank you.
I'm going to start off with the issues that have already been addressed with this example. If while my next door neighbor is out of town, I decide to try to lease his house to a tenant, and I sign a contract that lists me as owner and landlord of my neighbor's house, and the tenant signs it, that does not make me the owner of my neighbor's house, and it does not entitle me to receive rent from that tenant because I have no legal interest in the house. That is essentially similar to what has happened here. The trial court ruled on page 13 of the final decree of divorce that these billboards were corporate assets. And the court ruled that St. Charles Place was owned by Mr. Boone long before the marriage and that the corporation was his separate property. The billboards were owned by St. Charles Place or by Mr. Boone, but by listing Ms. Boone as an owner of the billboards on the contract, that did not make her an owner of the billboards, and it did not entitle her to receive income from the billboards. The court ruled that the income that had already been received in the past had been treated as marital property, and what remained of that money was in a joint bank account. The court found that that money was marital property because the parties had treated it as marital property. The trial court did not rule that income in the future from these marketing agreements would be marital property, simply the money that had already been treated and used for their personal purposes. I respectfully disagree with Mr. Caparella about one thing. He said that this is purely a question of law. I believe, as has been cited in both briefs, that the division of property in a divorce is a fact-intensive inquiry. It's de novo review, but with a presumption of correctness, and the ruling's not to be disturbed unless the evidence preponderates against the trial court's ruling. we really have a question of these contracts being enforceable at all, although that's not the issue before the court. It lists Miss Boone as an owner of the billboards, but she's never been an owner of the billboards. That's undisputed. It lists Mr. Boone personally as an owner of the billboards, and yet he did not sign personally. He took care to sign in his corporate capacity in both of them. So it's as messed up as it could be, frankly, except for one thing. The trial court found that these marketing agreements were corporate assets and the billboards were corporate assets based on these facts. They were purchased long before the marriage. Ms. Boone's name was never put on the billboards. Mr. Boone signed in a corporate capacity, and all of the income that was ever received under these marketing agreements was shown on the corporate tax returns, never on the personal tax returns of Mr. and Ms. Boone, and Ms. Boone never objected to that. But frankly, to go a step further, even if the trial court had found that these marketing agreements were marital property, the trial court still made an equitable division under the law. It's a tremendously short marriage. Ms. Boone did not put any money whatsoever into the billboards. The trial court doubted Mrs. Boone's veracity about her involvement in the business. Ms. Boone came into this marriage with absolutely no education, no business experience, and no expertise in the area that Mr. Boone had made his career out of. She put no money into the billboards. Mr. Hogue testified that he did all the work on the permits for getting the billboards approved. And Ms. Boone testified she was involved in obtaining a variance for the billboards, but the record then showed without doubt that her involvement was going to one meeting of the zoning board at which she didn't speak. She simply attended the meeting and watched. In our brief, in the appellee's brief on pages 30 through 34, we have cited two cases that I believe apply to this. One is Cronin Wright versus Cronin. The other is Lewis versus Francis. In the Cronin case, in a very short marriage, the parties bought a house. So it was acquired during the marriage and they titled it in both their names. So it was marital property, but the trial court and the Court of Appeals found that husband had no interest whatsoever, equitable or marital, in the equity in that house. In the Lewis case, a 2-year marriage, very similar to this one, the trial court found that wife's separate estate had increased by $1.4 million during the marriage. Out of that, and the court ruled that that increase was marital and awarded the husband $250,000. The Court of Appeals reversed that and said that husband had not contributed anything and it was a short marriage and there was no reason for him to have any of that $1.4 million. And the Court of Appeals reversed that $250,000 award. With that, I'm going to turn to the appellant's second argument that the matter should be remanded for valuation of marketing agreements. The trial court did not find that the marketing agreements were subject to division. And unless the marketing agreements are marital property subject to division, the court does not have to value them separately. Now, the trial court did find that Mr. Boone's separate estate was $11 million. And the trial court found that St. Charles Place was part of his separate estate. The appellant has cited the case of Green versus Green for the proposition that the case should be remanded for failure to value these two marketing agreements. But if you'll look on page 40 and 41 of Appellee's brief, we have cited two quotes from the Green versus Green case, and they're very short. And if you'll allow me, let me just read them. The court in Green said that separate property is not part of the marital estate and is therefore not subject to division. And then the Green court went on to hold, and this was the holding, because the trial court did not assign values to all the relevant property subject to division. the case had to be remanded. It was the failure of the trial court to assign specific values to property subject to division that required the remand. With respect to Ms. Boone's request for attorney fees on appeal, we have addressed this in the Appellee's brief. I believe the cases of Clymer versus Clymer, excuse me, and Henderson versus Henderson control this matter. And that is, there has to be statutory authority to award Ms. Boone attorney fees. The only two issues raised by Ms. Boone in this appeal have to do with the division of property. The statute says that the court can only award attorney fees on appeal if it involves alimony or child support. Clymer and Henderson are addressed on 42 and 43 of our Appellee's brief, and they're very, very clear that the court cannot award attorney fees on issues that do not involve alimony or child support. Finally, Mr. Boone, I have raised on behalf of the estate of Mr. Boone one issue, and that is that the trial court erred by not following the case law of Batson and its progeny in not returning the parties, quote, as nearly as possible, not exactly, but as nearly as possible to the position they would have been in had the marriage not taken place at all. Now, Batson is long established law, and on pages 29 through 37, we have cited detailed fact situations from 8 different cases that have come down since Batson. And all of them found that the trial court was to try to put the parties back as nearly as possible as where they had been. Ms. Boone came into this marriage with an estate worth $30,000. Now, her separate estate during the course of this appeal and the trial took longer than the marriage lasted. Her separate estate had grown at the time of trial to $228,283. In addition to that, the trial court found Ms. Boone should receive 60% of the marital estate, and her 60% was $155,486, 5 times what she came into the marriage with. Now, in addition to her separate estate of $228,000, a marital portion of $155,000, Ms. Boone also received this in a 23-month marriage. She received temporary support in the amount of $258,390. She received temporary attorney fees at the beginning of the divorce of $45,000. She received a new car that Mr. Boone was ordered to pay for, $39,650. And the trial court awarded Ms. Boone $140,000 additional in attorney fees for the trial. If the court adds that up, that is $483,000 that Ms. Boone received for a 23-month marriage, and her, in addition to the $155,000 out of the marital estate. I believe I have addressed all the things that I felt I needed to address. I'm certainly open to any questions that the judges have for me that I haven't addressed.
Counsel, who do you say were the parties? What do you say the proof shows as to who the parties were to the marketing agreement?
That's a real question as far as who the parties were. Mr. Boone signed as in his corporate capacity. Ms. Boone signed as an owner, which she wasn't. If Your Honor's asking me who owned the billboards. I
was asking who are the parties to the marketing agreement.
By the signature lines, the parties are Outfront Media, St. Charles Place, signed by the president of St. Charles Place, and Ms. Boone as an owner.
Okay.
And I go back to my example, Ms. Boone can sign those marketing agreements as owner all day long. And that doesn't make her the owner of the billboards any more than my example makes me the owner of my neighbor's house. Well, again, I want to thank Mr. Caparella. I want to thank the judges. I understand that this will be the last session of Zoom appellate, and I'm glad because I would have much rather been in Jackson doing this than on a TV screen.
That is all I'll say is that's the current plan. That was the current plan twice before, and we ended up having to change it. But we're hopeful that yes, this April dockets will be the last time on Zoom, and we'll be back. Excuse me, March dockets will be the last time on Zoom, and we'll be back in person in the courtroom starting in April.
Well,
we agree with you.
I'll look forward to it. I hope Mr. Caparella and I get to have some more appeals against each other.
Thank you, counsel. We'll hear from the appellant rebuttal.
Thank you, Your Honor. Your Honor, the analogy of somebody trying to sell the proceeds of their neighbor's house just because they're on vacation is not apt in this case, because the husband in this case had the authority to sell the advertising revenue from these billboard agreements. No one has argued that in this case, and no one can. So Your Honors can't say he had no authority, respectfully, to do this agreement when no one has even raised that issue. That issue is waived. So then you're left with, who are the parties? Well, the law says that when you sign an agreement in a representative capacity, and it just says St. Charles Place, Your Honor, respectfully, St. Charles Place is the name of a monopoly deed. We don't know, but based on just the four corners of this contract, who St. Charles Place is. We just know it's St. Charles Place. Well, when the agreement in no way references St. Charles Place, the law in the Sorkin case that we cited says that the idea that he signed in a representative capacity must yield under the clear exception of the rule to the language of the contract. And the language of the contract identifies the parties to this agreement, and that is Charles Boone, Dawna Boone, and Outfront Media. Now, parties can assign, as long as they have the authority, in this case, Mr. Boone certainly had the authority, can assign a stream of income to anybody they want to. And the contract clearly does that.
Counsel, I mean, the trial court specifically found that these billboards were the corporate property. Court allocates the billboards and our lease terms and other properties owned by the corporate entities to those corporate entities, not to the husband as his individual property for purposes of this division of marital assets.
Yes, but the trial court also found that the proceeds of all of these contracts was marital income in the past.
That went into the account, and it had been transmuted. Okay.
Right. But what I'm suggesting, Your Honor, is that under the legal interpretation that we believe applies, husband was a party to this contract individually, and the trial court was wrong in not treating this as marital property, because the legal interpretation under the Sorkin case makes it very clear that if you sign in a representative capacity, it doesn't make, if he'd written Donald Duck Land on here, that doesn't make it him signing this in representative capacity, because nowhere is it mentioned in the contract, and the parties are deemed to have read the contract and to understand the contract, and therefore husband can't sign in a representative capacity under the express terms of the contract, and the Sorkin case is directly on point. So
one additional question. Do you agree or do you contest the trial court's finding that this was a short-term marriage?
I do not, but I would submit that it's impractical unless the court wants to give the trial court the power to simply breach a totally appropriate contract. Then this is being an impractical application of the Batson rule, and wife should get an equitable piece of these two marketing agreements.
All right. Let me ask you, what provision in the marketing agreement should I look for where there's an assignment of an interest in the billboard and these proceeds by the husband to the wife? Is there a specific assignment provision in this marketing agreement?
Your Honor, it's better than an assignment. She is expressly made a party to the agreement, and as a defined owner to this agreement, she has a right to the net proceeds of the advertising revenue, 60% once per quarter. So she is better than an assignee, Your Honor, to this agreement.
So no assignment, but she's a party, right?
Exactly.
Okay.
All right, the court's thanks to counsel for both sides. We appreciate both your oral arguments and your briefs. We believe you've made the issues clear, and we look forward to resolving them. If you would please recess court until our next scheduled case.
This honorable court is in recess until 1 p.m.
Thank you, counsel.